punishment has been a controversial topic in the West for quite some time, especially in the United States, which happens to be the only Western industrialized nation that routinely puts people to death. However, concerning the United States of America, the death penalty is an acceptable punishment for murder where applicable, based on legal and moral evidence that counters key arguments against its use. This deadly form of discipline has been a part of America's recorded history since 1608, and with more than 16,000 people having been put to death by the state since that time. As time has passed, methods of execution have changed in order to suit the changing times and social values. Although not legal in every state, the current federally legal methods of execution are firing squad, hanging, lethal injection, execution, and lethal gas. No matter the method, the result is still the same: death. Certain legal disputations have arisen pertaining as to whether or not capital punishment is in direct violation of the Eighth Amendment, which protects individuals from cruel and unusual punishment at the hands of the government. Unfortunately, this phrase fails to define what constitutes as cruel and unusual punishment. The law is the collective expression of our belief in the human capacity for responsible action. It defines, authorizes, and enforces responsible conduct. The law's responsibility is nowhere more profound than in relation to death, a duty from which none can relieve it. The legal system, therefore, is responsible for ensuring that the death penalty is in no way a constitutional violation. Now, in modern America, murder is the main legal crime deemed worthy of execution as punishment. Even though the Supreme Court recognizes intentional killing as a crime to warrant the death penalty, it most certainly takes the Eighth Amendment into account before handing out verdicts. In the case Atkins v. Virginia, the Supreme Court ruled that it is cruel and unusual to sentence mentally challenged murderers to death. In Roper v. Simmons, the death penalty was ruled to be unconstitutional for murderers below the age of 18. And in 1976, the Supreme Court ruled that capital punishment is not itself cruel and unusual as long as it is applied within the use of objective criteria that allows for the consideration of a defendant's character and record. According to modern law, capital punishment is not a violation of the Eighth Amendment. Next comes the debate over whether or not execution is actually humane enough to be considered constitutional. While a case may be made against numerous forms of execution, such as hanging, little can be said against lethal injection, which kills a criminal by shutting down their central nervous system, paralyzing their lungs, and stopping their heart, a procedure for which the subject is unconscious for most of it. Humanitarian groups have cried foul over a very small number of botched executions by lethal injection, but the Supreme Court has ruled in the case Bays v. Reeves that not enough evidence exists regarding the infliction of pain to prove that lethal injection can be considered a cruel and unusual punishment. Therefore, at least one humane form of execution exists, as deemed by the Supreme Court. Next, the misinterpreted theory of retribution is often used as a moral argument against capital punishment, even though it was and still is used originally as evidence for capital punishment. Retribution may be defined as the rationally supported theory that the criminal deserves a punishment fitting the gravity of his crime. Many inaccurately see this as a form of unnecessary vengeance, but the problem with this generalization is that the rationalization behind legal punishment is that the accused should be given what he deserves. Many would argue that murder should be treated like rape, for instance, where the criminal does not have his own crime committed on himself. Murder, however, is so extremely different from any other crime in that it is the only crime capable of permanently robbing an individual of his unalienable rights, among which are life, liberty, and the pursuit of happiness. This is what sets intentional killing apart from all other crimes, making it deserving of death, and this therefore negates the argument that death itself, or the death penalty, is not a morally necessary form of recompense, due to the fact that for centuries, modern Western societies have substituted other forms of punishment in lieu of specific types of offenses committed by criminals. Christians tend to be against capital punishment because they often see it as a biblically unsanctioned form of vengeance. The problem with this argument is that in Exodus 21:12 verses 13, God declares that whoever willfully kills a man should be put to death. Nowhere in Scripture does God directly retract this command. Later on, in Romans 12:19, God instructs his people to never seek vengeance. If Christians believe that God is not a God of contradictions, then how could death as punishment for murder be considered vengeance? Forgiveness is important, but in order for there to be order, or in order for order to exist, there must be earthly justice. Murder is a very serious crime deserving of an equally grave punishment. Capital punishment has been used as an effective means of punishment for murder throughout much of America's recorded history. In regards to the legal and moral arguments and evidence discussed in this speech, there is no justifiable reason to not use capital punishment as the primary means of delivering justice in regards to murder.